Hi, I'm Wesley Phelps. I'm an assistant professor of history at the University of North Texas, and my paper today is titled The Adoption of Texas's Homosexual Conduct Law, 1965 to 1973. On February 20th, 1973, members of the Texas Senate witnessed something they had undoubtedly never seen in their political careers. On that day, 3 openly gay men arrived at the Capitol building in Austin to testify before the Senate Subcommittee on Criminal Matters in opposition to a proposed new state sodomy law. During the previous session in 1971, legislators had considered the adoption of a new state criminal code, the product of nearly a decade of work by a committee of the state's most respected law professionals. Of particular interest to these witnesses was the inclusion of Section 21.06, which made it a crime to engage in oral and anal sex only if the activity occurred between 2 members of the same sex. This was different from the current penal code, which criminalized oral and anal sex between both same-sex and opposite-sex partners, including married couples. The proposed 21.06 statute would be targeted directly at gay and lesbian Texans. Troy Stokes, a gay rights activist on the University of Texas campus, expressed his opposition to the proposed law by wondering aloud what harm this type of sexual behavior caused to society. When he had sex with another man, he told the committee, quote, "I don't see how in the world I harm myself or you." Fellow gay rights activist Frank Stovall argued that gay and lesbian Texans should be afforded the same control over their own bodies that the U.S. Supreme Court had recently recognized for women in its decision in Roe v. Wade, a case from Texas regarding the right to an abortion that the High Court had decided less than a month prior. The new sodomy law, Stovall said, would violate the bodily integrity of gay and lesbian citizens the same way the state's now invalidated abortion law violated women's right to control their own bodies. Dennis Milam pleaded with the members of the committee to withhold their approval of a sodomy law that would discriminate against a significant minority group in the state of Texas, imploring the legislators to reject the idea of openly discriminating against this large group of citizens, quote, whose love, affection, and sexuality is their only crime. Members of the Senate subcommittee listened respectfully to the 3 men before wrapping up their hearings, yet it was clear that the testimony of Stokes, Stovall, and Milam had failed to change anyone's mind about including the proposed sodomy law in the state's new penal code. I'd like to use my time today on this panel to explore the Texas legislature's decision to criminalize its gay and lesbian citizens by approving 21.06, which went into effect in 1974 and became known as the Homosexual Conduct Law. In 1965, state legislators appointed a special committee to perform an overhaul of the state's criminal laws, the first such revision effort since 1856. Chaired by Paige Keaton, Dean of the University of Texas Law School, the Penal Code Revision Committee initially recommended decriminalizing all consensual sexual activities conducted in private between adults, including oral and anal sex that had been prohibited in the previous criminal statutes, whether performed between members of the same or opposite sex. The following year, however, that effort at liberalization fell prey to state politics, and members of the revision committee walked back their proposal for fear that it might endanger the entire revised code when it reached the floor of the state legislature. By the time it finally passed the state legislature in 1973 and was enacted the following year, the state's new criminal code included Section 21.06, which again made all oral and anal sex between members of the same sex a Class C misdemeanor, punishable by a fine of up to $200. Despite the seemingly light penalty for infractions of the new law, many observers understood that 21.06 would serve as a basis for a range of discrimination, harassment, and violence against gay and lesbian Texans. In Texas, and in a majority of other states, there remained a stubborn resistance during the 1960s and 70s to change laws criminalizing the sexual lives of gay and lesbian citizens. And in 14 of those states, including Texas, sodomy laws like 21.06 remained fully enforceable until 2003, when the U.S. Supreme Court finally struck them down as unconstitutional in its landmark decision in Lawrence versus Texas. In April 1967, the Sexual Offenses Subcommittee of the larger Penal Code revision body presented its report during a meeting in Austin. The report defined deviant sexual intercourse as, quote, any act involving the sex organ of one person and the mouth or anus of the other with the intent of arousing or gratifying the sexual desires of any person. This was in contrast to what the committee defined as ordinary sexual intercourse, which, quote, occurs upon any penetration of the female sex organ by the male sex organ. Engaging in deviant sexual intercourse between adults would only be punishable by law, however, if force or threats were involved, or if one or more participants were unable to consent to engaging in the activity. In effect, the report called for eliminating the current sodomy law from the Texas Penal Code and decriminalizing consensual same-sex sexual activity between adults in private. Chairman Keaton endorsed this view, writing that laws against private consensual sexual activities between adults was out of step with a society based on freedom. Quote, if indeed ours is a free society, he wrote, the inescapable conclusion is that it is not the function of our government to attempt to establish an extensive code of morality through the use of the criminal law. Members of the revision committee also seemed to agree, as the meeting minutes show no indication that any committee member expressed concern about that part of the sexual offenses section. Keaton admitted, however, that decriminalizing private consensual same-sex sexual activity between adults would, quote, undoubtedly give rise to more controversy than any section in this article. This proved to be true 1 month later when members of the revision committee met to discuss Keaton's report on sexual offenses. During a meeting on June 21, 1968, only 9 of the 27 committee members were able to attend, giving this small group enormous power over the future of Texas laws regulating private sexual behavior. Inside a room in the Alumni Center at the University of Texas in Austin, these men participated in what became a critical turning point in the evolution of state sexuality laws. Several committee members stated flatly that they opposed, quote, legalizing homosexuality. Bexar County District Attorney James E. Barlow was the most outspoken in the group, exclaiming that if the prohibition on same-sex sexual activity were eliminated, quote, you would have every deviant in the United States coming to Texas. Barlow opposed changing the law because he, quote, didn't want to open Texas to homosexuals by legalizing it. San Antonio Judge Archie Brown agreed with Barlow, but was not as certain about punishment because, as he saw it, quote, sending a homosexual to prison is more like a reward than a punishment. At another time during the deliberations on this section, another member of the committee stated that sending a gay man to prison was like throwing Brer Rabbit into the briar patch. The report's authors retorted that the state of Illinois had decriminalized this kind of private sexual behavior in 1961 and were not aware of any problems caused by the legislature's action. Harris County District Attorney Carol Vance, however, stated that he had been in contact with his law enforcement counterpart in Chicago and that there was evidence of, quote, colonies of homosexuals in hotels in the city, presumably as a result of decriminalization. Committee member Glenn Connor stated that he had many conversations with police officers around the state and that they preferred that same-sex sexual activity remain criminalized, primarily because it was, quote, so destructive of moral fiber and so insidious, especially regarding the young. On the issue of opposite-sex sexual activity, however, the committee was in unanimous agreement. They did not want engagement in what they termed, quote, heterosexual deviant sexual intercourse to be a crime. This was a remarkable development in the process of revising the state's penal code. While committee members seemed to be persuaded that the state's sodomy law should not apply to opposite-sex sexual activity, many of them wished instead to target the law directly at gay and lesbian Texans. The actual motivation for criminalizing the private sexual activity of gay and lesbian adults, however, quickly became clear: politics. Several members of the committee worried about the reputation of the revision committee itself should they appear to condone homosexuality by eliminating laws against it. They were also concerned about the fate of their proposal for a revised code in the legislature if they took such action. Many legislators, committee members feared, might not support a revised code if the state's previous sodomy law were not replaced. Brown wondered aloud how, quote, a representative from rural Polk County can go back home and explain why he endorsed homosexuality. This argument ultimately carried the day, as committee members narrowly passed a motion to include a new sodomy law in a 5-4 vote, deciding they could not appear to condone homosexuality by decriminalizing the private sexual behavior of all adults in the state. Yet it was even worse than that. At least the previous law theoretically applied to all Texans. The new law, drafted by the Penal Code Revision Committee, targeted only gay and lesbian individuals in its application. A few years later, recent Southern Methodist University Law School graduate Randy Von Beadle interviewed 8 of the 9 Penal Code Revision Committee members who were present for this meeting. Only one committee member told Beadle that he believed reducing the frequency of private same-sex sexual activity was an important reason to include a statute making this activity illegal. Instead, nearly all of the pro-criminalization committee members reported that it was the possibility of an increase in the number of minors engaged in this type of sex, as well as a potential rise in other related crimes such as public sex and adult sex with minors, that motivated their decision to retain the prohibition in the new penal code. Beadle, as well as many committee members, found these fears unfounded, particularly since there was no evidence that the law affected the incidence of same-sex sexual activity among young people, and sex in public and sex between minors would remain felonies in the revised code. The other significant reason pro-criminalization committee members gave for their support of the statute was an assumption that if same-sex sexual activity were legal, the gay and lesbian subculture would become more visible and would perhaps even begin demanding that society recognize their equal rights. Further, those committee members who supported criminalization worried that it would be more difficult for employers to discriminate against gay and lesbian Texans if there were no laws against their sexual behavior. Beadle also found that many committee members worried that removing a criminal sanction for same-sex sexual activity would endanger the eventual success of the entire revised penal code when it reached the state legislature. In a related way, many committee members thought that if the state legislature approved removing the legal prohibition of same-sex sexual activity, it would appear that the state government approved of that type of behavior. Quote, the fear was that an illusion of moral imprimatur, Beadle noted, would cause those people who are on the borderline between heterosexuality and homosexuality, or as one member of the committee put it, are on the fence, to come down on the homosexual side of the fence, thereby resulting in more homosexually oriented persons. Political considerations and image, therefore, seem to be important considerations for most members of the revision committee. By 1973, when the Texas state legislature finally passed a revised criminal code, it was a foregone conclusion that private same-sex sexual activity between adults would be statutorily prohibited in the state. The new law criminalized individuals who engaged in oral or anal sex, but unlike its predecessor that had applied to all Texans, Section 21.06 of the new code applied only to citizens who engaged in that type of sexual behavior with someone of the same sex. The other significant modification of the previous sodomy law was the penalty for a violation, as under the old code the penalty was a felony that carried a 2 to 10 year prison sentence, while under the new code it was a Class C misdemeanor that carried a $200 fine. Many observers, including many members of the Revision Committee and the state legislature, undoubtedly believe that the reduction in the penalty for violating the state's sodomy law represented a more just and lenient way of punishing gay and lesbian Texans for their sexual relationships. Yet while individuals would no longer be sent to the penitentiary for engaging in this type of sexual behavior, the state's sodomy law nevertheless remained pernicious, precisely because opposite-sex partners were now exempt from punishment. Whereas the previous sodomy law had applied to all Texans, 21.06 singled out gay and lesbian individuals for an unequal application of the law. In other words, the law would now treat gay and lesbian Texans differently from everyone else in the state. It should have come as no surprise then that the new state sodomy law provided a legal justification for discrimination against gay and lesbian citizens in a wide range of areas, and in the process contributed to the ostracizing of a significant minority of Texans and the rendering of them to the status of second-class citizenship, making them vulnerable to a range of unequal treatment. Over the following few years, it became evident just how unequal gay and lesbian Texans had become as a result of 21.06. Thank you.